एक बार हम सुन लेते हैं इंटरनेशनल कोर्ट ऑफ जस्टिस में जो बातें हो रही हैं, उसका लाइव टेलीकास्ट उपलब्ध है, वो अपने दर्शकों को हम सुनवाते हैं वहाँ क्या बात हो रही है। कार्तिकेय मेरे साथ यहाँ मौजूद हैं, वो उसके जो हाइलाइट्स हैं, उसके जो की पॉइंट्स हैं, वो भी आपको अनुवाद करके बताएंगे साथ साथ।
Demande à maintes reprises, mais en vain. Le Pakistan lui a adressé une lettre sollicitant son assistance dans le cadre de l'enquête dont M. Jadhav et ses supposés complices faisaient l'objet. Les 21 mars et 10 avril 2017, le Pakistan a informé l'Inde de ce que la possibilité pour elle de communiquer avec
in the light of India's response to the said request for assistance. According to a press statement issued on the 14th of April 2017 by an advisor on foreign affairs to the Prime Minister of Pakistan, Mr. Jadhav was sentenced to death on the 10th of April 2017 by a court-martial due to activities of espionage, sabotage and terrorism. That it protested and continued to press for consular access and information concerning the proceedings against Mr. Jadhav. It appears that under Pakistani law, Mr. Jadhav would have 40 days to lodge an appeal against his conviction and sentence, that is until 19th of May 2017. But it is not known whether he has done so. India states, however, that on the 26th of April 2017, Mr. Jadhav's mother filed an appeal under Section 133B and a petition to the federal government of Pakistan under Section 131 of the Pakistan Army Act to 1952, both of which were handed over by the Indian High Commissioner to Pakistan's Foreign Secretary on the same day. The court may indicate provisional measures only if the provisions relied on by the applicant appear, prima facie, to afford a basis on which its jurisdiction could be founded, but need not satisfy itself in a definitive manner that it has jurisdiction as regards the merits of the case. In the present case, India seeks to found the jurisdiction of the court on Article 36, paragraph 1 of the Statute of the Court and on Article 1 of the optional protocol concerning the compulsory settlement of disputes, which accompanies the Vienna Convention on consular relations. I will refer to these instruments as the optional protocol and the Vienna Convention, respectively. The Court must therefore first seek to determine whether Article 1 of the optional protocol prima facie confers upon it jurisdiction to rule on the merits, enabling it, if the other necessary conditions are fulfilled, to indicate provisional measures. India and Pakistan have been parties to the Vienna Convention since the 28th of December 1977 and 14 May 1969, respectively, and to the optional protocol since 28 December 1977 and 29 April 1976, respectively. Neither of them has made reservations to those instruments. The Court recalls that the applicant seeks to ground its jurisdiction in Article 36, paragraph 1 of the Statute and Article 1 of the optional protocol. it does not seek to rely on the parties' declarations under Article 36, paragraph 2 of the statute. When the jurisdiction of the court is founded on particular treaties and conventions in force pursuant to Article 36, paragraph 1 of its statute, it becomes irrelevant to consider the objections to other possible bases of jurisdiction. Therefore, any reservations contained in the declarations made by the parties under Article 36, paragraph 2 of the statute cannot impede the court's jurisdiction specially provided for in the optional protocol. Thus, the court need not examine these reservations further. Article 1 of the optional protocol provides that the court has jurisdiction over, I quote, disputes arising out of the interpretation or application of the Convention, Vienna Convention, end of quote. The court will accordingly ascertain whether, on the date of the application was filed, such a dispute appeared to exist between the parties. In this regard, the court notes that the parties do indeed appear to have differed, and still differ today, on the question of India's consular assistance to Mr. Jadhav under the Vienna Convention. While India has maintained at various times that Mr. Jadhav should have been and should still be afforded consular assistance under the Vienna Convention, Pakistan has stated that such an assistance would be considered in the light of India's response to its request for assistance in the investigation process concerning him in Pakistan. These elements are sufficient at this stage to establish prima facie that, on the date the application was filed, a dispute existed between the parties as to the question of consular assistance under the Vienna Convention with regard to the arrest, detention, trial and sentencing of Mr. Jadhav. In order to determine whether it has jurisdiction, even prima facie, the court must also ascertain whether such a dispute is one over which it might have jurisdiction ratione materiae on the basis of Article 1 of the optional protocol. In this regard, the court notes that the acts alleged by India are capable of falling within the scope of Article 36, paragraph 1 of the Vienna Convention, which, inter alia, guarantees the right of the sending state to communicate with and have access to its nationals in the custody of the receiving state, as well as the right of its nationals to be informed of their rights. The court considers that the alleged failure by Pakistan to provide the requisite consular notifications with regard to the arrest and detention of Mr. Jadhav, as well as the alleged failure to allow communication and provide access to him, appear to be capable of falling within the scope of the Vienna Convention ratione materiae. In the view of the court, the elements mentioned sufficiently establish at this stage the existence between the parties of a dispute that is capable of falling within the provisions of the Vienna Convention and that concerns the interpretation or application of Article 36, paragraph 1 thereof. The court also notes that the Vienna Convention does not contain express provisions excluding from its scope persons suspected of espionage and terrorism. At this stage, it cannot be concluded that Article 36 of the Vienna Convention cannot apply in the case of Mr. Jadhav, so as to exclude on a prima facie basis the court's jurisdiction under the optional protocol. The court further considers Pakistan's argument that a 2008 bilateral agreement on consular relations, I quote, limits and qualifies or supplements, and of quote, the Vienna Convention, and that the court therefore lacks prima facie jurisdiction under Article 1 of the optional protocol. The court does not need to decide at this stage of the proceedings whether Article 73 of the Vienna Convention would permit a bilateral agreement to limit the rights contained in Article 36 of the Vienna Convention. It is sufficient at this point to note that the provisions of the 2008 agreement do not impose expressly such a limitation. Therefore, the Court considers that there is no sufficient basis to conclude at this stage that the 2008 agreement prevents it from exercising its jurisdiction under Article 1 of the optional protocol over disputes relating to the interpretation or the application of Article 36 of the Vienna Convention. Consequently, the Court considers that it has prima facie jurisdiction under Article 1 of the optional protocol to entertain the dispute between the parties. The Court then turns to the plausibility of the rights whose protection is sought and the link between those rights and the provisional measures requested. The power of the Court to indicate provisional measures under Article 41 of the Statute has as its object the preservation of the respective rights claimed by the parties in a case, pending its decision on the merits thereof. It follows that the Court must be concerned to preserve by such measures the rights which may subsequently be adjudged by it to belong to either party. Therefore, the Court may exercise this power only if it is satisfied that the rights asserted by the party requesting such measures are at least plausible. Moreover, a link must exist between the rights whose protection is sought and the provisional measures being requested. In its application, India asserts that the rights it is seeking to protect are those provided by paragraph 1 of Article 36 of the Vienna Convention.